Welcome to the Factoring Channel. I'm Scott Drake, and my guest in studio today is Matt Bracey with the law firm of Sheaf and Stone in Dallas. And we're going to do a series of discussions on the sale of structured settlement payments and factoring in general. Matt, welcome. In this first segment, I want to talk about the general annuity company policies and what's known as the best interest standard. Can you talk about that?
Right, Scott, and thanks for having me back. In a structured settlement, of course, there are a multitude of insurance companies involved. The annuity owner owns a policy that pays out the periodic payments that are due to the injured person over time. The policy is issued by another company. Typically, they're related, but not always. And the issuer is an annuity company that issues that annuity that makes those payments. Under the Structured Settlement Protection Acts of the various states, these are usually called interested parties. And what being an interested party means is that you get notice of the proceeding, you get notice officially that this transfer is taking place, and you get notice of the date and time of the hearing to approve it. And so that's their official role, let's say. What's happened over time is that some of these companies have taken a pretty active role in deciding that they have their own policies and criteria, if you will, for these transfers. And if you don't comply with them, what they'll do is they'll object to the transfer.
So, Matt, in these types of transactions, why do you think the issuers feel the need to participate?
That's a good question. I wish I knew the answer to that, honestly. I try to not assume ill towards anyone or that anyone's acting at a bad motive, and I don't think they are, frankly. I think what they're probably trying to do is to figure out, what this means for them. Just like a lot of the courts try to figure out, what does the best interest standard mean? What are they supposed to do? In this case, the insurance companies, I think, are trying to figure out what their proper role should be. I personally think that sometimes they go a little too far. And by adding their own policies and procedures and requirements on top of what the statute requires, they're really adding extra burdens. And again, what happens here is that if you don't comply with them, then they threaten or do object to the transfer. And what that means, what an objection does, is it can often cause a delay in the proceeding. It can, cause, sometimes the courts do listen to these objections, and they do overrule or deny a transfer based on the objection. And that's problematic for everybody. Remember, Scott, when a seller of a structured settlement comes to a factoring company, they come because they have an immediate need for some cash that was unanticipated. So they don't come because they know that 4 months from now they may need some cash. It's typically a right now thing. And every time you add a delay, it harms that person. And so these objections can delay the proceeding, and that causes harm to the person. And that's sort of the hammer that the insurance companies hold over the factoring companies' heads to make them comply with their own policies and procedures.
Well, finally, Matt, can you give us an example?
Sure. There are several examples, and lots of insurance companies, from very innocuous requirements to pretty stringent ones. The most ready example that I have is probably Allstate's, what they call the 6-month rule. And what the 6-month rule is it says that if you've completed a transfer within the last 6 months, they will object to you doing another transfer. I can see where they're coming from, I think. I think the idea here is that people shouldn't be, treating their structured settlement like an ATM machine, right? And not coming back continually trying to get more and more and more. It should be well thought out and carefully analyzed before they do that, before they come to the court and ask for a transfer to be approved. The problem with the 6-month rule is it ignores a very basic tenet of structured settlement factoring, which is that factoring exists because no one can predict with any kind of accuracy what's going to happen in the future. So when you sit around a settlement table and establish a structured settlement that pays some amount of money per month, let's say, for a guaranteed period of time, then you're assuming some things, and you're assuming that that amount of money will meet a need. and that usually does. Frankly, 92% or more of all structured settlements work exactly the way they're supposed to work. However, no one can predict the future, and if you can't predict the future 5 years down the road, I would suggest to you that you can't predict it 5 weeks down the road, or even 5 days down the road. So having a hard and fast rule that says you can't go back to the court and ask for another transfer to be approved within 6 months, I think ignores that reality. And I also think it's offensive in another way because it tries to take from the court what is the court's. And it's the court's providence to decide, is this transfer appropriate? Is it in the person's best interest? Should this be approved? And it's not in the insurance company's realm at all to decide that. And that's bothersome. So that's an immediate example that comes to mind. And, some courts, to my knowledge, I don't think a court has ever sustained the objection and denied a transfer because of the 6-month rule. And in fact, I know of a fairly recent case where they specifically rejected the 6-month rule objection and did look at the case itself and approved the transfer of payments.
Matt, thank you so much.
Thank you, Scott.
And you're watching the Factoring Channel.